public jointly as a commission, because the public is very anxious, the officers of course are very worried. These matters are not easy. If I that is why I pitched my response to saying my problem as the cabinet secretary for the national security is not the merits of the legal arguments, as my brother, the member for Homa Bay Town, and others are perhaps understanding. That's not my pitch. My pitch is the procedure of resolving differences of opinion, including interpretation of the law. If we allow that kind of conduct that we saw last week to continue, we are destroying our country. Unlike any other sector, the security sector is very sensitive because it's an armed sector. We have seen how one of our neighboring countries, the Sudan, has gone down because of primitive competition between two armed security formations. We are lucky the commission is a civilian institution, it's not armed. But you can imagine if we allow that culture, what would happen if you have an institutional confrontation between two security agencies which are armed. So my discussion with even the independent commission, Honorable Karuma, I understand the constitution so well. I've read it many times. The independence of constitutional institutions, including the judiciary, does not include the independence to destroy national security. That independence is, first of all, financial independence, which this administration has given to the National Police by allowing them to run the budget and not allowing the Office of the President to run their budget. So it's operational. Their operations are independent. It's also decisional independence. Their decisions are independent. But it ends there. Operational, decisional, financial independence, including independent commissions and judges and the judiciary. That's where independence ends. Any organ of the country's government infrastructure is subordinate to the existential needs of the country and is subordinate to national security. Because if we jeopardize national security, that independence cannot save us from our own destruction. So the fact that an institution is independent does not include us getting our hands off them, even if they are destroying our national security. Their independence is to make decisions, to conduct operations, to have their own budget, and nobody should interfere. But anybody who threatens national security, then now the what we call the primordial principles of democratic governance set in. That's how I understand that constitution. Not every article in that constitution speaks to the constitution. There are things, the existential principles upon which our democracy is founded are not even written anywhere in that constitution. Because you can waive your independence, then we destroy the country. Yeah. And I've said security sector, unlike any other sector, we cannot allow too much conduct that erodes public confidence. It's so sensitive, and that's why the president has directed all organs of national security must step out of political influences and political involvement, unlike in the past. because this is an armed sector. Between the organs we have, like the police and the Kenya Defense Forces, all the arms that this country possesses are in our hands. So if we are engaged in political and other things that are ancillary, you can push this country to the wrong direction. And I've given an example of what competition and juvenile maneuvers that ourselves can do to a country, especially in the security sector. Having said so, Chair, I do recognize there are express provisions of the law which must be respected, no doubt. I also do appreciate there are areas which are gray in this constitution, because the same constitution that the members are citing is the same constitution that says all organs of national security are subordinate to civilian oversight. All of them, including the Kenya Defense Forces, the National Police Service. So any officer who is interpreting the law to give themselves or their institutions untrammeled independence is wrong. But Chair, allow me to say this, because I'm generally also contributing, because I've captured the sentiments of the members, and I'm not here, Chair, to take sides. The oath of office as minister demands that I remain impartial and I apply my mind the most objective manner. So I have not come here to pitch or to pitch for one institution against the other or one state officer against the other. That would be against my oath of office. The specific provisions of the Constitution must be respected as far as possible. But at the back of our minds, I would want to ask members, even as you discharged your mandate, to reflect also on some of these issues. Like, for example, we have a constitutional setup, and which we must respect. But in terms of long-term national security policy, we need to ask ourselves whether we need to balance between the oversight, the civilian oversight, which is critical for the police, but also the ability of the police to run its operations and deliver optimal national security. Why do I say so? If we can, by way of analogy, give the example of KDF, where Colonel Russell was an officer before, the way they do things is slightly different, and the justification is there than how it's done in the National Police Service. The justification is there. But we might want, going forward, as we interpret the law and look at even law reform in the future, to enable so that we don't also tie police commanders' hands and demand too much from them. Let me say what I have in mind, and I do not claim to have the monopoly of knowledge. I could be wrong. Nobody is, except God, nobody is omniscience. The Inspector General of Police and the service commanders and that chain of command, in my view going forward, needs the law interpreted in such a way that they do not lose the room to be able to recommend, at the very least, to recommend an officer who they think can tackle a specific problem. For example, not every officer can go and command an operation against terror. Some are drunkard, and I'm talking from experience now. I've been minister for 7.5 months. Some wake up at 2 o'clock. There has been a raid, a cattle raid overnight, or a terror attack. The police commander or the OCS cannot be traced. Their phones are switched off. And this is an operation area. So the service commanders would know this officer has these capabilities, these competencies, and make a recommendation. And then we ask ourselves, even 246 talks about the power to recruit. What is the meaning of recruitment? Yeah? So we have to be careful and put all these things together for the national interest, not to promote one institution against the other or undermine one institution against the other. So in armed organizations like the National Police Service, in operational matters, the commander must have some input in saying this officer can do well in urban crime matters. This other officer has this competence, this very unique competence that cannot be displayed in the papers and the CVs of people, because it's an armed assignment. But on the other hand, the commission recruits, promotes. There's nothing that actually removes the possibility of a recommendation from the Inspector General, which is adopted by the commission after being justified. So you can actually achieve both objectives, where the commanders have some input to make sure that they have the right match of skills to deliver optimum national security without undermining the authority of the commission. So those are the synergies we are trying to, because even if we amend the law, even if we clarify the law, when there is bad faith and pettiness and small maneuvers, small-mindedness among institutions, we will not achieve what we want to achieve. That was my pitch. I was pitching my submission on higher values, higher way of doing things, and without undermining. The Inspector General of Police, the DIGs, are members of the commission. It's the commission that is recruiting. It's not the chairman of the commission who is recruiting. It's not the civilian commissioners. It is the commission and nothing prevents them from understanding the unique sector that commission is oversighting, to allow the commanders to have an input, because even when there is breakdown of security, we blame the commanders. You ask the IG, you don't ask the commission. So those approaches can help us put on board everybody, and it doesn't take away anything from anyone. I have told the IG, you're the commander of the National Police Service. Submitting yourself to a commission and asking the commission within the law to process your interests, because you are a member of that commission, and make sure the National Police Service Commission interest is processed, does not take away the fact that you are the commander of the National Police Service. I have told the chairman of the commission, listening to what the police commanders are saying, remove all the other issues of nepotism and whatever, those are illegal things. But an objective input from, in my view, an objective input from service commanders is critical for optimum security delivery of our country. Let's remove the personalities of who is the IG, who is the chairman of the commission. The input of an objective input of a Inspector General of Police and the service commanders is critical. And that doesn't undermine the recruitment objective or the recruitment mandate of the commission. Chair, also, I agree with the member who talked about ego. It's just about egos. Both the commission, the commanders, everybody thinks the only way people can know you are important is by showing and and practicing and just repeating it. And as a policy of this administration on national security, we will not hesitate to deal with any institution that threatens national security, whether it's independent or not. Because if law, Mr. Chairman, if law and order breaks down, nobody will remember any other matter. They will say the government has failed, the president has failed, the security minister has failed. So we will allow institutions to work, but they must promote national security objectives, and that's not a request. That is the demand of the primordial and foundational principles that inspire our constitutional democracy. Chair, we may have, now that we are a country that has over-legislated on literally everything. That's why our constitution is so long, so so elaborate. It says, you do this, and you can only do it from 8 o'clock. I don't know to what, because of lack of trust in people. So we might have to consider future amendments, the National Police Service Act, the National Police Service Commission Act, to promote some of the general mutually beneficial objectives that promote greater coherence for these two very critical institutions, because we need all of them. Then maybe I can also mention that why has this matter been loud, and I really don't know why it has been loud now, but we cannot have that again. We can't because action by the National Police Service Commission, which actually is in charge of the human resources within the National Police Service. That's a very serious action. Action or a decision by the Inspector General of Police, on whose every Kenyan is looking for a secure, environment, is very serious action. So when you have these exchanges in the public, no. Then I have two other small things, Chair, so that I return the floor to you. And this is my personal view, based on my experience in this ministry for the last 7 months, sorry. Again, this being an armed sector, we possess legitimate weapons of legitimate violence for the protection of the public. The best practice, even as we discharge our democratic, procedures, including parliamentary procedures, it is my suggestion that the reason why armed organizations like the National Police Service, the Kenya Defence Forces, are subordinate to civilian leadership. You find a principal secretary for internal security, a principal secretary for defense, a minister for defense, a minister responsible for internal security. One of the underlying legal philosophical justifications is to cushion commanders of armed organizations from too much public exposure that could undermine their role. Let me exemplify. Why do we remove the Inspector General of Police and the Chief of Defense Forces from matters procurement? Yet they are dealing with procuring of arms, and they're the best to know what to do. But you'll find in defense there's a PS, and then you have an accounting officer for the police. It's so that when issues of oversight, malpractices arise, you don't expose the commander to unnecessary scrutiny. You have a civilian officer, a PS, a minister, who is able to take that and engage. So my plea, Chair, and this is really a request, is we reduce calling our commanders for some, unless it is something directly on their mandate, like the preparation of estimates. It's in the law that the IG is responsible for the estimates, the budgetary and other estimates, that one, it could be called. But these other issues that are of policy and general nature, we reduce so that the commander is able to be cushioned from unnecessary exposure that can undermine their performance. And I don't know if I can get better language to explain. I'm not trying to say they should not be answerable. But you can imagine, let me give the defense, because the subject matter is the police, so that we get off from the names involved. You can imagine the chief of the defense forces being grilled over procurement issues, being told money was stolen, we think you're the one who stole, those kind of grillings. The confidence of that commander to be able to command and gain respect among the troops is diminished. So you bring in the PS, you bring in the minister, they take all those issues. The commander, his work every day is to make sure that the performance of the troops is optimal, and he has the confidence, the respect that is required. So some of these things like this, if you ask me, instead of asking IG, I'm here, PS Omolo is here, the accounting officer of the National Police Service is there, and unless it's really something really touching on him, again, that is my view, and I'm not trying to say that they should not be the subject of the mandate of this committee, just minimizing so that we don't expose them to too much dirt, too much public exposure that undermines their ability to command respect as commanders of armed institutions. Finally, the last one is going forward. Again, this is for the future, because we have our constitution, which we must respect as it is. We may want to think through for the future, maybe 50 years, 100 years to come, because we are not doing this because of the current IG and the current commission. We are doing this for our country. We may have to reflect on the National Police Service Commission. I've given a lot of examples from the defense side. Let me give other examples by way of analogy to explain why I think we need to rethink how the commission should be enabled to perform a little more optimally with less of these noises that we are hearing. You have an independent commission under the same chapter 15, called the Parliamentary Service Commission. It is chaired by the Speaker of the National Assembly. It is independent. It is no less a commission. It's not lesser than the other commissions, but because of the unique role of the legislature, the chair of that commission is the Speaker of Parliament. Another example, the judiciary. There is an independent commission from the same chapter that Honorable Kaluma was referring us to, called the Judicial Service Commission. The chair is the Chief Justice and President of the Supreme Court. Why? Because of the unique role of the judiciary, which might, if you have a separate commission headed by a separate chairperson, and the very unique, fundamental, and sui generis role that the judiciary plays in our democratic order, you are likely to have frictions which can undermine confidence in the judiciary to deliver justice and the rule of law. Parliament, the same. So I'm just wondering, and I am for civilian oversight and subordination of the National Police Service to civilian authority, because that's what the Constitution says in Article 240, 239, 240. So similarly, in the future, we may have to think that how we have a commission doing the same job, protected as the current commission, but without bringing friction with the commanders in the manner in which I have given with the examples of parliament and the judiciary, but that is something for the future. For now, we must live with the constitution as it is. We must respect it and process our differences in this very sensitive sector in a manner that does not erode public confidence in our security organs. As I end, the public exchange of unpleasant, untidy, derogatory messages between the leadership of the National Police Service and the leadership of the National Police Service Commission is an affront and a dangerous attack on our constitutional order and on the integrity of our national security. I expect it will end, and all the clarifications and the interactions and the whatever needs to be done should be done within established institutions and outside the public layer. And Chair, finally, there was that little matter which was brought by the member for Larry, the Honorable Kahangara, on regularization. You see, I was very careful. When I met this gentleman, I was very careful because I tried to weigh my words. Regularization doesn't mean, I didn't say what regularization means. I just told them, go and follow the law. They should follow the law. That's it. So I just say, go and follow the law. Officers needs to be promoted, go and follow the law. As to who recruits, go and understand the meaning of recruitment. As to whether the IG has any role, go and read the Constitution, follow the law. So that regularization is not trying to say that what so-and-so has done or has not done is right or wrong, because I would be wrong to take sides in a matter as sensitive as this one. Thank you, Chair. And for civilian staff is provided for within the National Police Service to make sure that our officers do not engage in non-core duties. You don't want a police officer doing other duties which are necessary, but it should not be done by an officer. The officer work is to just make sure that they provide security to the people of Kenya. And that approval was given, I think, by the accounting officer of the National Police Service, made a request to the Treasury approved. So the recruitment from where I sit was done in accordance with the law, and that process is ongoing. There is nothing wrong with it. And in case there are any issues in the same manner, they should be resolved within the procedures that we are having. But it's a legitimate exercise done in accordance with the law, and whatever issues that may arise should be resolved in the coming days. Kenyans should have confidence in us. The little matters that have, as the member for Elgeyo Marakwet has said, was our own mistake, because we went public with things which are necessary. I promise that it will not happen again, and I want to apologize on behalf of the Inspector General of Police and the National Police Service Commission. I want to apologize as the Minister for Interior for these two institutions for exposing our very, very strategic institutions to public embarrassment. I apologize.
So you can just move now.